Hi everyone, my name is Delene Grant and welcome to part 7 of my presentation on Naimark Law Firm, the criminal activities of Naimark Law Firm, Ryan Naimark, Courtney Madison, who joined forces with Hicks Morley Law and Nicolini Law to falsely represent my cases. Okay, please feel free to pause and read as I go along if I'm going too fast. Okay. It was now Naimark Law's turn to complete its deception. Ryan Naimark and Courtney Madison, oh yes, and they were really working at it. 2019 to 2022. Okay. September 2020 continued. Monday, September 28th, 2020. Call received in the morning to inform that, let me pause there is an email right from Courtney in my previous presentation that said they were gonna call me Monday evening. I would have been prepared. So in this case, I was caught off guard. Okay, so a call came in, but luckily it was, I put it in writing and she actually confirmed. Okay, so I'm glad she confirmed. I'm not making up stories on this lawyer. Okay. All right, I'll start over. Monday, September the 28th, 2020, call received in the morning to inform that they, Naimark Law and Defense, had misguided me towards an examination for discovery, which should have been a mediation first. Therefore, the examination for discovery dated September 29, 2020 will have to be cancelled. I was coerced and shouted at. I told you about Courtney's attitude. Yeah, she had disrespected me till she, remember in one of the conversation, she apologized. She said that way she is with her clients. Okay, I was coerced. She coerced me to move over all my cases, and here she's coercing me again to cancel. Oh my. I was coerced and shouted at when I refused to accept. Told Courtney Madison I needed time to think. Right? This lawyer had done nothing because they got everything prepared from Benjamin Law and from Sanford to Markin Law. And in the meantime, not knowing that they have not done anything for my motor vehicle accident claims. Well, right? I already went through that on my presentation on motor vehicle accident. Oh, this lawyer sat on it. So he said they did not intend to help me at all. They keep at the time I didn't realize that this was what was happening, right? That this lawyer was really out to ensure that they do not represent me at all. They, as Courtney had made mention in her previous conversation, she said, she gave me the rundown. She said, first is a discovery, then mediation, and then like maybe pre-trial or something. Here she's telling me that they misguided me because this mediation is first. Can you imagine? Right? Wow. Never-ending lies upon lies. Okay? So here, Monday, September 28, 20, at 2:03 p.m., right? I even have to look this up. And I had an appointment. I wasn't even late for my appointment. I was late. Yeah. Because I was trying to I looked this up online. This is the link. I found this information when to consider mediation. Here I said, unfortunately, I was caught off guard when this call came in. I was not in a position to record. Once again, I was shouted at by Courtney Madison because I was not accepting her decision to cancel the examination for discovery again. My trust level for this lawyer had now decreased to 0. I guess it was 0 a long time, but the worse. It's now worse. Okay. The information here is the same. So which one you can see better? I tried to enlarge it a bit so you can see. So you know either which one you can read. I've highlighted here. I said here, I've given thought to our conversation this afternoon in regards to canceling my examination for discovery scheduled for tomorrow, September 29, 2020, and instead have a mediation 1 month. She said it here, 1 month from the date of settle day to settle my case for wrongful dismissal, long-term disability. She wanted me to want to do mediation, eh? How come you're going to do a mediation and I don't even know anything about my case? This lawyer and I are not on the same page. As a per conversation you heard that she said when she was trying to be, when she was using psychology and me, she said she'd take out things and whatever, what was not needed anymore or whatever. How dare her? Wow, really? I want to do a mediation? Oh, definitely not. Okay, as I said, you had indicated that a mediation should have been offered instead of an examination for discovery, because mediation is usually the first option. I said, since I was fired from my place of work with a disability, I am still waiting for over 2 years, over 2 years later, to have to sit and discuss my cases with a lawyer. You heard that? I am still waiting over 2 years later to sit and discuss my cases with a lawyer. I thought this was a normal procedure. I had informed you that my statements of claim were incorrect, especially the claim for long-term disability. So many things have happened in the 2 years, therefore requires us to meet and discuss. Okay, then when I went online, as I said, I look it up and it says here when to consider mediation. Anyone you like to read, it says a mediation can be held anytime after the parties recognize that they have a dispute. I mean, after this examination for discovery, right? In litigation, most mediation are held after the examination for discovery and after all necessary documents have been disclosed. That way the parties come to the mediation with all the necessary information. You understand? So this lawyer realized that I'm too smart for her. So she just want to nip it. She just want to nip it in the bud. Let us go to a mediation. Okay, please feel free to pause and read. Thank you. I've enlarged it. I spent a long time on this one, but I'll try to go faster on the others. Okay, thank you. Monday, September 28, 2020, same day email received at 2:19 p.m. to inform that E, I do not have a wrongful dismissal. She said, I do not have the wrongful dismissal documents yet. And F, Bell proposed that they want to divide up the examination into wrongful dismissal, wrongful and disability examinations. Why would Naimark law require more time? After a year and 1 month for my wrongful dismissal case, Naimark law had already received statement of claim and statement of defense from Sanford to Markin law, right? And in August 2019. Okay, so here I'll enlarge this. September 28, 2020, 2:19. This information, I brought this, I included this because I've doodled on it. So please feel free to read. But this information is the same as this, all right? I included here, examination for discovery long-term disability was already scheduled for August 16, 2019 by Benjamin Law. This law firm, Naimark Law, did not do anything for me. They got the work already done by Benjamin Law and Sanford Markin Law. All Naimark Law needed to do at this point in time is to schedule the examination for discovery. All you have to do, if they want to schedule it, say 3 months later, I will understand, because they need to get familiarized with the documents, with the information, right? No. Oh, wow. Read it again. Examination for discovery long-term disability was already scheduled for August 16, 2019 by Benjamin Law Firm, but was cancelled when I retained Naimark Law Firm on July 26, 2019. Naimark Law deliberately ignored the long-term disability case for over a year, of which they had combined with the wrongful dismissal case to further confuse my cases. Then to be told it was consented that both cases should be separated. They're the seat and I must pay the cost. To delay me further, eh? Please feel free to review here. It says, from Courtney Madison to me, right? Monday, September 28, 2020 at 2:19 p.m. She said, I confirm I have recommended to you that we engage in settlement of discussion and adjourn your discovery by 1 month. The mediation, but anyway, discovery by 1 month. This is helpful strategy for a number of reasons, which I have explained to you. I do not have the wrongful dismissal documents yet. She told me that by phone on Friday, the 25th. Okay, I have your disability documents from Bell. Bell proposed they want to divide up your examination into wrongful and disability examinations. Remember, they combined it in May. Nicolini Law and Hussein Mufti, they combined the statement of claim in May 2019. And then in July 2019, Naimark Law did the same by correcting the name from Bell Canada to Bell Mobility, and it was combined. And now they're saying Bell want them to be separate. Wow. And then she said, I will need 1 day for the employer and 1 day for the disability consultant. It is dangerous for you to testify about your disability claim without reviewing the wrongful dismissal documents. It will not be dangerous. I know what happened. You see, when you're a liar, you have to make sure you write down what you say, because maybe a year or so later, if you don't remember what you said then, you would tell another lie and it would not be consistent. Now, my situation, ask me anything at any time and I would tell you, because I'm talking the truth. I don't have to make up anything. All right? So I don't know why she think that I'll be in danger. No, I will not be. Not be at all. I said here, I did make mention, right? I'm paying the cost for their deceit. Right? Feel free to pause and read. Thank you. Here, and I will enlarge this. It says here, Courtney Madison did on September 28, 2020 at 2:19 p.m. I do not have the wrongful dismissal documents. You can see that, okay? All right. Here on for September 26, 2019, right? Remember, September 26, 2019, when they were they scheduled the examination for discovery, right? And it was for Grant versus Mobility. You see the deception? It was scheduled for May 15, 2020, right? Retain Naimark Law on July 26, 2019. Naimark Law received the statement of claim and statement of defense from San Farouk to Marking Law. However, I had to wait 10 months, July 2019 to May 2020, for examination for discovery, wrongful dismissal, which never happened. Can you see that? Right? It simply means that if they're scheduling this, it simply meant that they were prepared or they needed 10 months to prepare what they were waiting within the 10 months. Then after when the 10 month came, they lied and they actually put me off to September. Here you go. Same thing, wrongful dismissal, Grant versus Bell Mobility, right? Date of loss, May 24, 2018, same thing. And this was May 6, 2020. See the different dates, okay? And it says it was put off until September 29, 2020. Don't you see this lawyer did me wrong? Huh? I said here, as per Naimark Law, during COVID, the defense lawyer, that's what he said, that's why he postponed it. The defense lawyer did not trust the Zoom platform for the examination for discovery, therefore rescheduled for another 4 months, May 2020 to September 2020. Naimark Law had everything for both wrongful dismissal and long-term disability since September 2019. Still have not met with the lawyer once, but waited for over a year for a settlement. Also had not heard anything about the examination for discovery long-term disability, which was cancelled on August 16, 2019. Look at what this lawyer did. You understand? Feel free to pause and read. Thank you. As you can remember, again, I've brought this one forward so many times. Retained Benjamin Law on February 13, right? Right? And this was long-term disability information here. Benjamin Law. The deception was communicated to the Benjamin Law firm and Sanford Law firm, right? In May 2019. Benjamin Law was long-term disability. Sanford law firm was for wrongful dismissal, right? And they indicated here that they're going to combine. You see, our office was in the process of amending the long-term statement of claim, all right, to include Bell Canada as a defendant. We received consent. Consent, that's the word underlined here. On February 26, 2019, February 28, I should say, 2019, from Defense Counsel. Wow. If you feel, pause and read. This was what I was showing you anyway. Thank you. There was a G. Oh my, I didn't see this one coming. All right. After so many different reasons, remember, if you're telling a lie, be consistent. All right. Write down what you said. Okay, after so many different reasons, six others, to cancel the examination for discovery dated September 29, 2020, I received a final email from lawyer Courtney Madison, dated September 28, 2020, at 3:19 p.m., which stated, I understand that there may have been some confusion when rescheduling the examination that was booked before we were retained. Our office believed it was both the long-term disability and wrongful dismissal issue. On exchanging documents and communicating with counsel last week, we came to find out that it was only the long-term disability matter that was scheduled. Wrongful was to happen separately. As such, those documents have not been produced to us as yet. Go figure. A year later, Courtney Madison already had in her possession the statement of claim, wrongful dismissal, and other documents from Sanford Marking Law since September 2019. Wow. And I didn't, you see, this came in 3:19 p.m. I was at an appointment, okay? All right, please feel free to pause and read as I go along. Thanks. This information here is over here. This is at 3:19. All right, same. I doodled on this, that's why I included it. So please feel free to read if you wish. I indicated here, Naimark law, wrongful dismissal documents have not been produced to us as yet. 3:19 p.m. Okay. It's stated here again from Courtney on Monday, September 28, 2020 at 3:19 p.m. She stated again, okay, let me go back from the beginning here. This is further to our call just now. All right. I asked you to read the email below sent at 2:19 p.m. and confirm your instruction. All right. So I read that previously, right? Again, I would highly recommend that you accept my advice to put over the discovery 1 month and focus negotiating a settlement in the interim. I would tell you, Courtney told me. She told me on the phone that they misinformed me, misguided me. The examination, the mediation come before examination for discovery, and I actually put it in writing to her. I guess she's correcting what she said, because I provided the information to her that a discovery come before the mediation. So she's using discovery. I put it in writing to her because that's what she said to me. That's why I had to look it up. Okay? And provided the link. All right? I knew what she said. Unfortunately, I didn't get to record her, but at least now I said she wants to move it over for a month. Right? She said discovery 1 month, as you can see here, and focus on negotiating a settlement in the interim. You said you are frustrated and upset, and you would not and could not understand why you are waiting 2 years. Wouldn't you be? You it's obvious that I've been taken for a ride, huh? would you remain calm? At least I wasn't shouting at her or whatever. I let her know that I'm not pleased about the whole thing, eh? Yeah, because I realized what they are doing. And then she's saying, I cannot speak to the time before that. The lawyers before that were doing me right. They were doing me right, except it's just that I was disappointed with David Vaughan Sanford to Marking Law. That's the only thing. I was disappointed. But he was on the right track until he got mixed up with the other lawyers, okay? My job is to provide you legal advice. You're not providing me legal advice. My advice is to adjourn the discovery tomorrow to focus on settlement discussion. You hear? You see here? It says settlement discussions. If the negotiation fail, then we go to discovery or a mediation. Settlement discussion. What's that settlement discussion? Mediation. Okay? And it says here, I understand there may have been some confusion when rescheduling the examination that was booked. How can you be confused? That's another breach. I'm expecting to represent me? Huh? Wow. You confused? Okay. No, I think it was a deliberate act. Okay. And it says, I understand there may have been some confusion when rescheduling the examination that was booked before we were retained. Our office believed it was both the long-term disability and the wrongful dismissal issue. On exchanging documents and communicating with counsel last week, we came to find out that it was only the long-term disability matter that was scheduled. Wrongful was to happen separately. As such, those documents have not been produced to us as yet. So, if the documents was not produced as yet, what was going to happen on May 15, 2020? If the document was not produced as yet, why postpone the examination for discovery for September 29, 2020? And because now I started to intervene and asking the necessary questions, all of a sudden, a lot of confusions. Wow. Then she said here, I do not have all the documents for wrongful dismissal, and in speaking with the defense lawyer, I am not comfortable producing you for the discovery because I cannot reasonably see how the two issues would be parsed out. If questions are asked about the employment issue, I should have a copy of those documents received before the examination. Demanding to proceed tomorrow without good reason may compromise your claim. Then it says here, you said you would receive my email and reach out after 3 p.m. because you were running an errand. I didn't tell her that I had an appointment. If we do not hear from you by 3:45, this is what the lawyer did again against that contract. If we do not hear from you by 3:45 p.m., we will cancel discovery so as not to incur a cancellation charge. The cancellation charge have to be on them. Okay, my thing here is this lawyer, as you can see, has been deceitful. You understand? I knew about, even if she had the discovery the next day, I could answer questions on my long-term disability. I could answer questions on my wrongful dismissal. But as she made reference in our voice message, in our conversation on a previous presentation, she did say that they took out things. They took out things and did other things. I would tell you this lawyer got everything, including the kitchen sink, as Jamaican would say. Jamaican would say, you understand? She got everything. So all the documents, especially when you have seen me in the past there, sending stuff over. And she did say, I don't have to send it over. She will get it from Sanford to Marking Law. Sanford to Marking Law had everything. And if she got the documents from my file from Sanford to Marking Law, she's supposed to have everything. So what does she mean? She does have everything? Feel free to pause and read. Thank you. I've enlarged it so you can review. Okay, thank you. Examination for discovery, long-term disability dated August 16, 2019, cancelled. This was the only examination for discovery that was scheduled by Benjamin Law Firm for over a year. Naimark Law deliberately informed me of an examination for discovery, wrongful dismissal under false pretense. Naimark Law had not involved me at once in my cases to be told This error was before they took my case. Naimark Law was following the instructions of Hicks Morley Law and Nicolini Law to delay my cases, then tried to force a mediation after so many damages. Previous lawyer, long-term disability, Benjamin Law. Benjamin Law, February 2019, long-term disability. Examination for discovery, long-term disability was scheduled for August 16, 2019. Phone call received from Liliana Benjamin Law on May 23rd, 2019, yes, to inform of the upcoming examination for discovery, long-term disability scheduled for August 16, 2019. I was advised that a letter would follow with details, which was received in July 2019. Okay, I received July 2019, and I did get a call on May 23rd, 2019. I did document. I did not record the call or anything, right? I did document that the phone call was received, right? And it says here, long-term disability LTD of May 8, 2018. All right, Benjamin Law, as you can see, and it says here, please be advised that we have scheduled examination for discovery in regards to your claim for August 16, 2019 at 10 a.m. at the office of, and they have the information and the address, right? Then it says, we have also scheduled a preparation date. You see the difference with the lawyers now? Benjamin Law has scheduled a preparation date for you at our Toronto office. And it told you where the address is, right? And the preparation date would have been for August 2nd, 2019 at 11 a.m. This lawyer was going to prepare me for the examination for discovery for August 16. All right? I didn't have to plead and ask him whatever. He had documents before him, so he's going to make sure that we're on the same page. All right, please feel free to pause and read. Examination for discovery, long-term disability scheduled for August 16, 2019. Benjamin Law Firm, February 13, 2019, was successful in scheduling the examination for discovery within 6 months. Okay, 6 months. All right. There's the information that I read. Please be advised. Feel free to pause and read. I've enlarged it for you to see what I have read earlier. Examination for discovery, August 16, 2019. Preparation date would have been August 2nd, 2019. All right. New lawyer, July 2019, long-term disability and wrongful dismissal. This was Naimark Law. Examination for discovery dated August 16, 2019, cancelled. Reason, because I retained Naimark Law. Naimark Law was my new lawyer, okay? Motion filed in the Superior Court of Justice against me in 2021 brought the following forward to confirm deception by Naimark Law. All right? I've been through this in another, I brought it forward in another presentation, but I'll try and go quickly. All right? Thank you. Denied number 17, I tell you. Examination for discovery, wrongful dismissal and long-term disability because of Hussein Muftadiri, Adrian Nicolini, Ryan Naimark, and Courtney Madison. I had to bring this one forward since motion was filed against me in the Court of Law in 2021 for both cases. The motion filed were not the same that were communicated to me for over a year, okay? As you can remember, all right, I will bring this up. When I got the information from Naimark Law, is for September 26, 2019. It was Grant versus Bemobility, wrongful dismissal. As you can see, right? And it says date of loss, May 24, 2018. So we're talking about wrongful dismissal here, right? The date for the examination for discovery was Friday, May 15 at Friday, May 15, 2020 at 10 a.m. Okay, as you can see, wrongful dismissal. I'm trying to go fast, so please see with me. Okay, and then from retrieve from motion, Ontario Supreme Court, notice of examination scheduled for May 15, 2020 was long-term disability, manufacturer's life insurance, and industrial alliance insurance. The same thing that was cancelled at August 16, 2019. Discovery for long-term disability. This was it that was scheduled for May 15, 2020. But Naimark Law misguided me and said it was wrongful dismissal. As you can see, I didn't get this information at all. Please feel free to read. I didn't get this information. So it says the manufacturer's life insurance, and it says this is for long-term disability. As soon as it's manufacturer's life insurance, it's long-term disability, but it's not. It should not have been for manufacturer's life insurance. It should be for industrial alliance insurance. Okay. Anyway, this is what filed in the court. Notice of examination, right? And it says here, Friday, May 15, 2020, commencing at 10. And at the same place, if you look 77 City Center, 77 City Center, right? And I didn't get this. There's an X here, examination for discovery. So the court have it that's going to be long-term disability, while Naimark law has it that I'm going to have the wrongful dismissal discovery. All right, please feel free to pause and read. Thank you. And as you can see, 26, I brought it closer, enlarging it for you. September 26, 2019, Grant versus Mobility, date of loss, May 24, 2018, guarantee. This is wrongful dismissal, Friday, May 15, 2020, 10 a.m. Okay, no meeting with lawyer to discuss case, all right? And then for, I've enlarged the one that came from the Ontario Supreme Court of Justice. It says Manulife Insurance and Industrial Alliance Insurance and Financial Services Inc., which is for the long-term disability. And it says same date of the previous, May 15, 2020, 10 o'clock. The addresses are the same. Please feel free to go back if you wish. And it's for examination for discovery. So court have one thing and lawyer misguided me by giving me wrong information. Okay, please feel free to review. Thank you. Retrieve from motion. All right. Just while I got the letter, right? The letter from Naimark law dated 26/2019 indicated grant versus vulnerability, right? And the court file dated October 3rd, whereas you can see here, October 3rd, 2019, indicated the manufacturer's life and alliance insurance and financial services, as you can see. Only letter above, okay, dated September 26, 2019 was received via mail. All right. Were the lawyers confused, or do you believe this was deception? Feel free to pause and review. Thank you. Okay, 2. Here, all right, because of being their deceit, actually, right? Here, they're saying that the defense Hussein Muftadiri, Higgs Morley law, or it was Amy Tibble or whatever, they were saying that they do not want to use Zoom because they do not trust Zoom. Okay, so my wrongful dismissal claim, okay, was rescheduled. So on May 6, 2020, right, they stated that the Mobility Inc., date of loss May 24, 2018, as you can see, is for wrongful dismissal, right? It was postponed until Tuesday, September 29, 2020 at 10 a.m. Please feel free to review. However, when I pull this from the motion, Ontario Supreme Court, please feel free to pause and read, okay, the same thing, but it says it's Manulife Insurance, Manufacturers Life Insurance Company and Industrial Alliance, long-term disability, that is, right? Notice of examination. And it did say that the changes was it was rescheduled Tuesday, September 29, 2020. Okay? Again, examination for discovery. This is saying wrongful dismissal. And this one from the court is saying long-term disability. Feel free to pause and read. Okay? I enlarged it again for you. Okay, May 6, 2020, Grant versus Bell Mobility Inc. May 24, 2018. Clearly, this is wrongful dismissal. And it says it was, here's a new date, September 29, 2020, 10 o'clock. Please feel free to pause and read. That's from Naimark Law Firm, okay? Now from the Court of Law, Ontario Court of Law, it says the Manufacturers Insurance Company and Industrial Alliance. And this is for long-term disability, as I said to you, okay? And they have it that there will be a change there Tuesday, September 29, 2020, commencing at 10. And it's examination for the discovery. Be free to review, okay? Thank you. Deception. And as you can see, retrieve from motion, date May 6, 2020. That was from the court. Because again, everything remains the same. The same thing on May 6, 2020, same as above. What I would have gotten, I got May 6, 2020, but it was for belt mobility. Wrongful dismissal, not money, life insurance, long-term disability. Please feel free to pause and read. Thank you.